Hello and good evening, everyone, and welcome to this evening's webinar on Special Needs Trusts. Without further ado, I'd like to introduce our panelists for this evening. First, we have Bhavik Patel, who serves as the current CEO and chairman of the Executive Committee for Sandberg and Phoenix. Next, we will have Casie Stevens, who is the Director of Trust Services with Midwest Special Needs Trust, and her partner, Shelley. And finally, we will have Michael Chiodini, who is the Principal and Financial Investment Advisor with Chiodini Financial Group. So without further ado, I will turn it over to Bhavik Patel.
Hello, everybody. Nice to, meet you all today. So you have a panel of experts today to talk about a variety of aspects of a special needs trust. But I'm going to kick it off today to kind of set the stage and kind of give you a little background information as to public benefit eligibility rules, what they are, what the eligibility rules are, or how do you continue to stay eligible for Medicaid and SSI rights and things like that, so that you know where special needs trusts actually fit in terms of helping your overall planning. And so I will kind of kick this off by giving you a very quick overview about public benefits eligibilities, what tests are looked at, how you're going to qualify, things like that. And then I'll end on a summary of sort of the general types of special needs trusts. ARC puts on a more detailed workshop and presentation on public benefits as a whole, and it gets a lot more deeper than what we're going to cover today. This is just kind of a prelude to understanding the importance of special needs trusts. But here's how I'll sort of categorize it. There are two types of public benefits that our government offers us. And the way I categorize these two types of benefits, it's the one that is not based on financial need. For example, Social Security, Medicare, special education. And then there are the benefits that are based on financial need. And those are very commonly the two most important ones we'll talk about: supplemental security income, known as SSI, and Medicaid. And so when we're talking about what we're talking about here today, special needs trust, we're really talking about how to advance the strategy so that your loved one with a disability can continue receiving or not have disrupted any of their SSI or Medicaid benefits. In other words, how do we not disrupt the benefits for your loved one with a disability based that needs it based on financial need? So then, kind of taking that to the next level, let's talk about supplemental security income. What exactly is it? Again, it's a federal financial need-based public benefit. It's a federal program, and it's administered by each state from state to state. But essentially, you have to prove two basic things. You need to prove sufficient evidence of disability, and then you have to prove financial need. Okay. And so I'm going to, instead of keep saying loved one with a disability or a child with special needs, I'm just going to call that individual, for just to kind of make it a little bit more personable. I'm going to call that individual Joey. And so Joey has to prove the financial need. And depending on how old Joey is, we will either be looking at Joey's financial need alone or Joey plus Joey's parents' financial need. And so that cutoff age is 18. So if Joey's under the age of 18, to establish financial need for Joey, we are going to look not only at Joey's assets, but we're going to also look at Joey's parents' assets. If Joey is 18 or older, then we will shift that and only look at Joey's financial assets. Okay. Just real quick again, SSI is intended to pay for Joey's food and shelter and really not anything else. Now, the big tests to determine eligibility for SSI really come in two forms. One is called the resource test, and the other is called the income test. I kind of want to paint an analogy or a visual for everybody to understand the differences between these two tests. Picture yourself in front of a locked door, and on the other side of that door is benefits, SSI and Medicaid benefits. Well, the way I describe the resource test, that's the test that needs to be passed in order to unlock that door. So passing the resource test unlocks the door. And then you look at the income test to decide how wide is that door going to be open. I know that's kind of a funny or a very simple analogy, but I really want you to really think about that analogy for a second. Our job, as parents of Joey, is to make sure we can do this planning in a way that never shuts the door and locks the door. So let's kind of talk about that resource test. What exactly is the resource test? And remember, failing the resource test locks the door. Passing the resource test allows that door to be unlocked so you can get benefits. So whenever I hear a test, and that's called resource test, anytime I hear a description of a test, my very first question I would ask is, what resource test? So what is a resource? And so I want you to think about a resource, at least at this point in time. I want you to think of a resource as anything that can be converted to cash. So I'm going to stop there for a quick second, because what I've just described is really everything. I mean, even the shirt I'm wearing right now is something that could technically be converted to cash. It may be not a lot of cash, but it could still be converted to cash. So I want you to start the thought process here in understanding the eligibility rules to say anything Joey has asset-wise is a resource, whether it's his clothes, whether it's a bank account, whatever. Now, I'm going to step back from that here in a second, and I'm going to tell you there are certain assets that are excluded from the resource test. But I want you to start by thinking everything is a resource. So then, knowing that, what exactly is the test? Well, for SSI purposes, if Joey has more than $2,000 in assets or in resources on the first day of the calendar month in which Joey applies for SSI benefits, then the door is going to be locked. If he has less than $2,000, then the door can be unlocked. Now, you'll see on my PowerPoint there's a different number for Medicaid eligibility purposes, $5,035 for Joey to have resources not to exceed roughly $5,000 for Medicaid eligibility. That's great. It's a higher number. It's moving in the right direction. It's still overall a very low threshold, but I want you to leave today's presentation and I want you to just remember the $2,000. And yes, I know, even though it's being recorded, that is an inaccurate statement. It's the safer number to remember. Just Joey cannot have resources above $2,000. And that could up, and you just apply that in your mind to SSI and Medicaid. Technically not correct because it's $5,035 for Medicaid, but I would just keep it simple. Remember the same number and assume it's $2,000. Okay, so I told you the resource test is anything that can be converted to cash, and that is basically everything. And that if you are underneath that threshold, the door is unlocked and you can qualify for SSI. And if you qualify for SSI and meet the resource threshold for Medicaid, you'll qualify for Medicaid. But I do want to make sure you understand certain assets are excluded from the resource test. In other words, excluded from that $2,000 threshold. What are those exempt assets? Well, a home, for example, in which Joey resides in that home. So if ever Joey needed to no longer live in that home, this could become a problem. But as long as Joey lives in the home and Joey ends up owning that home would be an exempt resource for the resource test. Now, please do not hear what I said to mean, oh, it's okay if Joey owns a home. That is not the strategy. It's not the recommendation, because Medicaid can attach a lien on Joey's home and then it could recover its expenses incurred on Joey's behalf upon Joey selling the home or upon Joey's passing, that there could be that lien. It isn't an optimal strategy. But at least for getting the door to be unlocked, a home can be owned by Joey, and we're going to ignore the value of that house in the resource test. Household goods. So that's just kind of like all the stuff around the house, furniture, iPad, all of that in aggregate together, not totaling more than $2,000 in market value. I really don't focus too much energy on that exemption, and neither has any of the public agencies, because it's really hard to prove who owns the iPad. And so it's not an area that I have seen them use too often to disqualify someone from public benefits. Another exempt resource, and it sounds very morbid, would be if Joey had a prepaid funeral. And that's an asset technically, because it's an expense that's prepaid. And so it ends up actually being an asset for Joey. And technically I said anything that's an asset of Joey's would be a resource, but this is specifically excluded from the test. And so think about a scenario where maybe Joey ends up getting some inheritance or cash, and that cash is going to lock that door to public benefits. Well, one potential solution would be to take that cash that's otherwise preventing you benefits and converting it to an exempt resource, like a prepaid funeral, as an example. Also, an automobile, that doesn't have a current market value of more than $4,500. So I kind of make the joke, a relatively unsafe vehicle maybe is an exempt resource. However, if the vehicle is necessary for employment or medical treatment, or to physically transport Joey, like one of those customized handicap accessible vans, then the entire value of that vehicle is an exempt resource. Again, those handicap accessible vans can easily be $100,000 in value. And so I wanted you to understand the breadth of that potential exemption could be meaningful for you, for your particular circumstance. Another one that I don't really spend a lot of time is life insurance. This is life insurance owned by Joey that has a cash value of less than $1,500, not death benefit, a cash value. If Joey ended up having a term life insurance on his life and he owned it, that entire term life policy would be exempt because term life insurances don't have a cash surrender value. Again, not one that really comes up a lot, but I wanted you to be aware of it. Assets put in an ABLE account, as long as those assets in an ABLE account are under $100,000 in value, they will not disqualify Joey from Medicaid, for example. One downside to the ABLE account, personally, I think an ABLE account's an amazing rescue tool, meaning if all of a sudden Joey has assets that's disqualifying him from public benefits, it's great to take some of those assets that are above the threshold and throw them in an ABLE account. But I don't think of ABLE accounts as very really good proactive strategies. In other words, I would not put my money into an ABLE account for Joey. Now, if Joey had money that's causing him to be disqualified, I can see why we would put that in an ABLE account, mainly because Medicaid can also attach a lien or get reimbursed the costs that it incurs on behalf of Joey out of the ABLE account upon Joey's passing, if any is left over. So just something to think about there. But really the segue is assets in a properly drafted special needs trust are exempt. So if you're following sort of what I'm talking about, and you're trying to get to public benefits for Joey, and you have a door in front of you, and that door is locked, and you pass the resource test to unlock it, and then you start seeing how much of a benefit you're getting based on the income test, which I'm really not going to even talk about today because that's really for another workshop. All I'm saying is assets in a properly drafted special needs trust will never lock the door. So this is a way for moms and dads and grandparents and uncles and aunts and siblings to be able to have assets left for Joey in a way where Joey can benefit from those assets to supplement his life without locking the door for benefits. So I'm going to stop there because I think there might be some questions. Do you need to communicate the value of a special needs trust to Medicaid or SSI? When you're doing the application, they're going to ask you if there's a special needs trust, and they're going to ask for a copy of that special needs trust. And it's very likely they're going to ask you for potentially a disclosure of the assets or the value of that special needs trust. None of that should scare you. All of that's fine to disclose, and none of it should, quote, lock the door to public benefits. But I'm going to put a big but in there. But only if the special needs trust is valid, like if it's drafted correctly, whether it's, and this is where I'm going to go into this in the presentation here in a second, but whether it's a customized, privately one done through like a law firm, or whether it's the type of special needs trust that you can get with the Midwest Special Needs Trust Group that you'll learn about here shortly. But as long as the trust is done properly, yes, you should communicate it when they ask you, and you shouldn't be scared to do so. Is it possible to have my inheritance go directly into a special needs trust without losing current benefits contingent on income? The answer is yes. That's probably a very simplified answer. Yeah, I mean, the whole point of the special needs trust, again, is to be exempt from the locking the door. So yes. And then if it's a properly drafted special needs trust, it should also not impact the income rules in a way that would cause less benefit than a maximum benefit could get you. I want to talk to you about sort of the different categories of special needs trusts. And then I want you to kind of highlight 4 or 5 things that are sort of common pitfalls and why special needs, or where special needs trusts can come in to really help the planning strategy. I'm going to kind of give you sort of this is not like textbook explanation of the different types of special needs trusts, but I really see 2 broad categories of special needs trusts. In one category, I'm going to call it the reactive category. And then the other category, I'm going to call it the proactive category. Okay. And in the reactive category, what we're really dealing with and why I'm calling it reactive is Joey is possessing money or has received income of some sort of, whatever is going on with Joey, he is receiving assets that is walking him down the inevitable path of having the door lock in front of him. And so it's kind of like, I'm about to lose my benefit, so I need to react. I need to do something. And one of the strategies, like we talked about a second ago, this potential strategy of prepaying a funeral, or we talked about in these exempt assets earlier about putting some money in an ABLE account. Well, another strategy is to put money in a specific type of special needs trust. That reactive type of special needs trust is called, it has many names, often called a first party special needs trust or self-settled special needs trust. It also can come up, it can also have a name that's called a D4A trust, but often commonly referred to as a Medicaid payback trust. All kind of doing the same thing. So it's a way to say, Joey's got money, Joey's door is about to get locked, so Joey needs to do something with it. So he's going to throw it into a Medicaid payback trust. So it sits in trust for his lifetime. It no longer disqualifies Joey from public benefits. And then when Joey dies, Medicaid would get reimbursed however much cost it incurred on Joey's behalf, provided those assets remain in that trust at the time of Joey's death. Okay, that is called a reactive special needs trust in my terminology. Now, shifting over to the proactive zone, and look, I mean, I'm using these words purposely because I think it's always beneficial to be proactive. It's always catching up to be reactive. So proactive actually has are called third party special needs trusts. Third party, meaning it's not Joey's money yet that's going into the special needs trust. So for those of you on this call, if you were like, when I pass away, I'm going to leave Joey money. Well, you leave it in the third party special needs trust. And now it's in the special needs trust. It's exempt from the resource test, so the door stays unlocked. And because it never was Joey's money, it never was in Joey's hands, Medicaid cannot attach a lien to it and get reimbursed money from that trust upon Joey's passing. So that's why I say it's more superior to have a proactive type of special needs trust. And that is again called a third party special needs trust. Third party because it is not Joey's money going into it. Now, there are two types of third party special needs trusts. There's what we call a standalone, which is you create the trust document now, you sign the document, and now it's in existence and it's ready to receive money from whoever is going to leave that trust money, whether it be you during your lifetime or a grandparent that's going to leave it to Joey while you're still alive, or whatever the case may be. Or a testamentary third-party special needs trust, which is basically a special needs trust that's dormant, asleep, and it doesn't actually come to life until mom and dad die. And then mom and dad's estate planning feeds the inheritance into that third-party special needs trust. Okay, so that's me being very, very simple in categorizing generally the types of special needs trust. Reactive, proactive. Reactive is Medicaid payback trust. Proactive is third-party special needs trust. Now we have learned, and I'm just kind of piecing this whole thing together, we know what we need to do to keep the door unlocked to benefits. We have to pass the resource test. We know that a special needs trust is a way to have assets held for Joey's benefit, but keep the door unlocked. And we know there's multiple types of special needs trusts to accomplish the objective to keeping the door unlocked. So then I'm going to end on these 5 things that's on the screen right now that says, here are things that we see people do that I want you to be weary of. And then I'm going to explain what a special needs trust can do to sort of rescue the situation. So the first thing you see there, common things that people do all the time, like just these general transfer to minors act accounts, like a custodian account to for Joey, like where it's to mom and or dad as custodian of Joey because of a birthday check or a accumulation of birthday checks over the years, and they're depositing this into an account. And that basically is a transfer or a custodian account, or what is often known as a transfer to minors act account. Well, the problem with that is definitely an easy way to give mom and dad control of the money for Joey. And it's easy to open up an account, deposit the check, all of those things. The problem is it's not an exempt asset. So at some point, it could cause Joey to have to calculate that asset as to whether the door is going to be locked or unlocked. And so oftentimes I tell people, if you're going to give a gift to Joey, maybe you just give a gift to me and I'm going to put it in a bank account just in my name and I will use it for Joey. Or you can go ahead and be proactive and create that third-party special needs trust and then have some people write the check actually in the name of that special needs trust. And that special needs trust owns the bank account. And then you're depositing the checks into the bank account that's owned by the third-party special needs trust, in which you're in charge of or you're in control of as the trustee. And then you don't have the door locking on you that way. So there's a couple of ways to solve that issue. And then you have another common pitfall is unstructured beneficiary designations. So this is like your 401k, your IRA, your life insurance. I mean, a lot of you probably have a job. When you started that job, you went through sort of orientation, filled out a bunch of paperwork. Part of that paperwork might have been, do you want the employer paid for life insurance, or do you want to set up for 401k or pension plan or whatever it is? And then they actually have you put beneficiary designations on those assets. And a lot of you that are married might name your spouse as the primary beneficiary. And then your secondary beneficiary, you might have just named your kids. Well, I'm here to say if you've named your kids and Joey is one of your kids, that's a problem, right? Because if you pass away and your spouse predeceases you, then that means that asset is going to go in equal shares to your kids, which includes Joey. So now Joey's going to receive money, and that's a problem because money is going to lock that door. So where does special needs trust come into play? Well, you do a change of beneficiary form, and wherever it said Joey's name, you need to take Joey's name out and you need to reinsert the special needs trust for Joey. So let's say you had 2 kids and you had 50% going to your daughter, Emily. The other 50% was going to Joey. We need to take Joey's name out and say that other 50% is going to the special needs trust for the benefit of Joey, or whatever that trust is titled. And now when you pass away, it will actually go right into that special needs trust. It'll be a third party special needs trust, which is the good kind. And voila, you don't have the door locking on you type of situation. Directing funds to be held informally by another family member is something we hear. So I just introduced the daughter or the sister to Joey, Emily, in this example. A lot of people will do their own planning and just say, oh, I'm going to leave everything to Emily. And then Emily will take care of Joey. But at least Joey has nothing, so the door can never get locked. And technically that might be true, but in my maybe completely biased opinion, it's kind of cruel, in my opinion, to Joey. Like, I'm going to disinherit Joey, and that's how I'm going to protect Joey. That just doesn't sit right with me. Instead, you give it all to Emily, and I kind of tell people all the time, well, is there a guarantee that Emily's going to use that for Joey? And maybe the answer is yes, maybe it's no, I don't know. But what if Emily dies? Or what if Emily gets sued? Or what if Emily gets divorced? Then all this money that you've left to Emily to help take care of Joey is now with her ex-husband or the person that sued her or whatever. So there's too many unknown variables, in my opinion, to take this gamble on Joey. I mean, instead, the solution is you don't need to disinherit Joey. That's the whole point of a special needs trust. You can leave the right amount of value of assets you think is right to Joey via his special needs trust. And then you have, what if grandparents or uncles or aunts or someone like that wants to leave money to Joey? That having a special needs trust is a great way for you to approach a conversation to the grandparents or uncles or aunts or whoever and say, hey, listen, I don't know if you're going to send or leave money for Joey, but if you do, I need you to leave it to him in this special needs trust. And here's the title of it. We've already created it. And there you go. That's very important because, grandparent just is wanting to help Joey out. It's a beautiful thing. But if they don't do it in the right way, it could have a beautiful heart, but a terrible consequence. Locking that door, losing benefits. You kind of get it there. So, and then the last thing is no planning at all for you that's listening in right now. If you don't have your own version of an estate plan that says where your assets go when you pass away, well, then the state in which you live in has one written for you. The problem is those plans written by the state that you live in, if you don't have something already prepared, says that, hey, when you die, the assets that you own individually, half of them are going to go to your spouse if you're married, and then the rest of everything, or all of it if you're not married, is going to go in equal shares to your kids. That's no different than the beneficiary designation example I said earlier. All of a sudden, your kids, because you've passed away, are going to get a portion of your assets. That's a problem. That's going to lock the door. It's going to blow the resource test. So you don't have the luxury of not doing something. Now, you don't have to go about and do like some advanced, complex, expensive planning. Heck, a lot of good estate planning doesn't even require a lawyer at all. You just need to be intentional with what you're wanting to happen and make sure things are going to go into a special needs trust for Joey. And so that's kind of why I wanted to walk you through sort of these pitfalls, because then you can kind of see where the value of a special needs trust is. I have 2 children with special needs. Can I just have one? I assume you mean, can you just have one special needs trust? And so the answer is, it could literally be one document, but you really do have to have every special needs trust must have. One of the terms of that special needs trust is it must have exclusive benefits to the special needs beneficiary. So you can't have one special needs trust benefiting multiple beneficiaries. Now, you can literally have one document that splits into 2 special needs trusts, one for each of your children, but don't do the pot, like multiple beneficiaries of one special needs trust. That'll get you in trouble. So just keep that in mind. And then the last question I have on my screen is, if the beneficiary of the trust dies, does it go to their named heirs? And the answer is most likely yes. If it's a proactive category, third-party special needs trust, and it's one that is custom drafted, like law firm drafted, like someone like me drafted, then when Joey passes away, the rest of those assets would pass on to wherever we said it would go to, based on what you said you wanted it to do when you prepare the documents. If it's a reactive Medicaid payback trust, remember that after Joey dies, whatever's left over should first be used to pay back Medicaid, and then whatever's left over would go wherever you want it to go. And then I'll let Casie and Shelley answer what happens if you use the Midwest Special Needs Trust. In general, it will go to whatever family you highlighted in the document, but there may be a carve out for charitable purpose that they can kind of highlight a little bit further. I think that might be all the open questions. And so I'm going to pass the baton on to Casie and Shelley.
So some of you that may have seen Midwest Special Needs Trust present before or heard me speak before may have seen a very different PowerPoint. This is one I use to kind of break down those very large concepts that Bhavik was talking about. So we're going to go through this, and our concentration is going to be in you as a caretaker. So you as a family member of an individual with a disability, what can you do to preserve the benefits of your loved one? And I'm going to try and stick with the name Joey. I know that's what Bhavik used. I tend to lean toward Johnny. So if I switch back and forth, I'm meaning the same person. I wanted to, before I get too far into this, introduce Shelley Morse. She is a trust specialist too here at our organization, and she's going to jump in periodically and give us a little bit of information and hopefully educate us on some distributions and allowable distributions from special needs trust. So today this evening, we're going to learn about the 3 types of special needs trusts, as well as ABLE accounts. I know we had some questions about ABLE accounts and about the different types of special needs trusts. Hopefully I answer those. And if I have time, and somebody's probably going to have to just turn my mic off for me when it's my time to go, talk about a comparative analysis. So we're going to compare special needs trust and ABLE accounts and how maybe one is beneficial versus another and when they both might be beneficial. So a little bit about special needs trust in general. They are established for the sole benefit of the person with a disability. I'm going to pause right there. So the question about, can I have 2 special needs? Can I have both of my children in one special needs trust? I wouldn't recommend it either, right? Because the provisions of a special needs trust document require a sole benefit provision for the person with a disability, meaning the trust cannot be used for anybody else. It is a financial planning tool available to individuals, families, and friends, utilized for supplemental needs and not basic support. So we learned that supplemental security income is to pay for food and housing, right? We learned those 2 things. And a trust is to pay for anything that's not that basic support. So SSI is going to cover, supposedly, right? That's our hope, going to cover housing and going to cover food. And the trust can then supplement all of those other monthly costs. And we're going to talk about what those monthly costs could be. Governed by trust language and applicable statute. So there is a federal statute for special needs trust. And then here within Missouri, specifically for Midwest Special Needs Trust, there's a state statute. Attorneys, banks, and pool trust organizations are all options for establishing and administering special needs trust. I'm not going to sales pitch you this evening about Midwest Special Needs Trust and all of the great services that we offer. What I want you to walk away with is that there are options for you and that a special needs trust is an option. A properly administered special needs trust is considered an exempt asset for SSI, Medicaid, food stamps, and HUD housing. So public benefits, considered an exempt asset for SSI, Medicaid, food stamps, and HUD housing. We're going to jump right in here. So we have first party special needs trust. So first party, self-settled, Medicaid payback, D4A, all of those, that technical language that Bhavik told us about, that's a first party trust. They are established by a parent, grandparent, guardian, the court, for the benefit of an individual with a disability under the age of 65. And also the individual can now also establish their own special needs trust with their own funds. So it's important to note that it is the beneficiary's assets that are funding a first party special needs trust. What are those assets, right? Back payment from Social Security, unplanned inheritance. So mom and dad had no plan. They didn't plan for their death to leave funds to a special needs trust for Joey. So it's an unplanned inheritance. Settlement from a lawsuit. So personal injury settlement can also fund a first party special needs trust. They are irrevocable, meaning you can't pull the funds out if you're mad at the trustee. You can't close the trust because you don't like the administration. It is irrevocable. And as Bhavik explained, there is a Medicaid payback requirement. So at the end of the trust, closing due to a low balance or death of the life beneficiary, Medicaid is going to come back and say, hey, you were allowed to have this trust while you were living or while it had funds in it and it paid for your supplemental needs. Now that you're no longer using the trust, we're going to put a lien on the remainder balance for the amount that we paid for your Medicaid benefits while you were living or while this trust was in place. So I want to make it very clear that with a first party special needs trust, there is a Medicaid payback requirement. Oh, I have a couple of examples. Kelly is a 9-month-old with a physical disability. She receives a personal injury settlement in the amount of $100,000. Would a first party trust be appropriate? So obviously Kelly at 9 months is not walking to the attorney's office and settling her own personal injury settlement, right? But on her behalf, parents on her behalf receive these funds. They have some options to protect her Medicaid benefits and potentially any SSI benefits she may receive. Would a first party trust be appropriate? The answer is yes. Since these funds are from a personal injury settlement, sorry, my slide is wrong there. Thank you for me remembering that. A first party trust would be appropriate. Susie is 36 and was diagnosed with a mental illness. She receives a back payment from Social Security in the amount of $16,000. She's also a recipient of Medicaid. Would a first party trust be appropriate? So we talked about those assets. How can somebody fund a first party trust? With the Social Security back pay? So yes, because the funds are from a Social Security back payment, a first party trust would be appropriate. So now we're going to switch gears. So we have some examples of first party funds. Those are clearly the beneficiary's funds. Those are the person with a disability. Those are Joey's funds that he now needs to remain eligible for Medicaid, remain eligible for SSI. He's going to put that into a first party trust. On the other hand, we now have third party trusts. So we have third party special needs trusts. They are established by a donor, not the person with a disability. So this is that proactive approach. They are the donor's assets, and assets can include cash assets, investments, 401ks, real estate, all of those things that are considered assets, the donor can put into a special needs trust. These typical sources of funds include personal funds, life insurance policies, and wills and estates. They can be revocable or irrevocable. So the donor can decide, do they want to have the ability to revoke this trust, or do they want to make it irrevocable at the time of its creation? And upon the beneficiary's death, so once the beneficiary passes away, there's no Medicaid payback provision. The funds in the third party special needs trust go to whomever the donor listed as beneficiaries within that trust. So I use the word remainder beneficiary, some use just beneficiary, but upon the beneficiary, why the trust was established, their death, the assets are distributed per the donor's wishes. Again, no Medicaid payback because they were never the beneficiary's funds. So a third party trust is somebody planning on behalf of the individual with a disability. For example, Heath is a 3-month-old with a seizure disorder. His grandparents want to fund a trust for him with their life insurance policy. Would a third-party trust be appropriate? The answer is yes. Since the funds are Heath's grandparents, a third-party trust would be appropriate. They're not Heath's. He doesn't have those funds yet. They haven't written him a check or written him a check for his parents to cash on his behalf. This is Heath's grandparents wanting to fund a trust for Heath. Xavier is a 5-year-old with a disability. His family has decided to save money for him, each contributing up to $5,000. Would a third-party trust be appropriate? And our answer is yes. These funds would be considered his family's funds, so a third-party trust would be appropriate for Xavier. So those are the two major special needs trusts, right? So we have first party, which is the beneficiary's own funds. That's Joey's money. He's received funds and he needs to remain eligible for public benefits. Then we have third party, which is somebody giving money to Joey through a special needs trust. That is not, they are not his funds. They are somebody else's funds for his supplemental needs. Then we have this extra special needs trust, right? This is where Shelley and I are well-versed in what pooled trusts are. Pooled trusts are established by a nonprofit organization with individuals, beneficiaries creating accounts within the larger trust. So you're signing up essentially for a pooled trust. They are pooled for investment and management purposes, but accounting has remained separate. Because the funds are pooled, this is usually a low cost option. So pooled trust organizations are notoriously lower than costs associated with a bank or a private trustee. First-party trust must be established by parent, grandparent, guardian, or the court, or the individual with a disability of any age. And remainder funds are used to help others with disabilities. So pooled trusts are allowed to retain a portion of the funds at the closure of the trust for their charitable mission. I'm not going to talk about my charitable mission. If you have questions about it, I'm happy to respond to that. But our charitable program is called the MS&T Charitable Grant Program, and we retain a portion of the funds at closure due to death for our charitable mission before we pay back Medicaid or before we pay back any remainder beneficiaries. So Jacob is 1 year old. He has a personal injury settlement of nearly $200,000. His family goes to a bank. They've heard about special needs trust. They've heard me talk, and they say, we need to do a special needs trust. And the bank says, that's not enough money. We can't do that. Where can Jacob's family go? Would a pooled trust be appropriate? Yes. Pooled trusts have a very low minimum balance, so a pooled trust would be appropriate for Jacob. And this would be considered, because it's a personal injury settlement, a first-party trust. Anne is 22 years old. She receives an unplanned inheritance of $95,000. The attorney administering the will tells Anne she needs a special needs trust. He doesn't have the staff to provide the correct oversight for this kind of trust. He's like, I know you need one. I don't know what to do about it. Would a pooled trust be appropriate? Yes, a pooled trust would be appropriate for Anne. And because it's unplanned, we would need to do a first party trust. And I'm going to let Shelley tell us about allowable distributions for a few minutes.
Well, I have the opportunity to talk to you about allowable distributions through a trust. And while on the screen you're seeing several distributions, this is not an exhaustive list, but it covers quite a lot of ground. So let's go ahead and just go through some of the items on the list. So medical and dental are allowable distributions through a special needs trust. And these expenses would be medical and dental that are not covered by another source. So a lot of the individuals that we serve that have the special needs trust have Medicaid or Medicare or even private insurance. So the costs that are allowable are those that aren't covered by other sources. Supplemental and support services, rehabilitation, training and therapy services, education. That's, I think, a nice distribution. We have a lot of people that use funds for education for vocational training, certificate programs, and some that have even utilized funds for pursuing a 4-year degree. The irrevocable prepaid burial policies. Looks like we have a spelling error there. I apologize for that. While these plans are not always the most fun to talk about with families, and families don't oftentimes want to think about a prepaid burial, this is something that we do like to talk about and cover with individuals with special needs trusts, because those funds are allowable distributions, and it's best to use those funds to make those purchases, because once a beneficiary has passed, those funds are no longer available for purchase of funeral expenses or any kind of burial expenses. So one of the conversations that we have to have on a fairly regular basis that is very difficult with families once a beneficiary has passed is about being unable to pay for that kind of expense. We can't pay for funeral expenses once a beneficiary has passed. And that's with any request. we are not able to process any requests for funds once a beneficiary has passed. Clothing is an allowable expense, non-food grocery items, so household items, personal care items, transportation, personal property. A lot of people have purchased vehicles through their trust. Travel expenses, this is transportation, lodging, and food for the beneficiary, as well as an additional person for travel. Home modifications, we've done some, had some requests for some really good home modifications. We've been able to repair or replace wheelchair ramps and, you know, put grab bars into bathrooms and various places, replace doorknobs with door handles. Just home modifications are definitely an allowable distribution. Very common distribution are phone, cable, and internet services, entertainment items and events, and ABLE accounts, which Casey's going to cover a little bit in more detail here in a few minutes. But one of the things that Casie mentioned earlier was that a special needs trust can be utilized for supplemental needs, but not basic support. So things like food, rent, utilities, those are all things that are not allowable expenses. But I'm going to let her talk about ABLE accounts and she can cover a little bit more.
What does ABLE stand for? So it is the Stephen Beck Jr. Achieving a Better Life Experience Act of 2014. I would be lying if I didn't start following the ABLE accounts all the way back in 2011 when they were just a mummering. And so I am fully invested in what the ABLE accounts can do, how they can serve individuals with disabilities and their families, and giving folks information about the ABLE account. So I am not going to tell you that I am an expert in ABLE accounts or how they are administered, but I can answer some pretty general questions. And if I don't know the answer, I know where to point you in the right direction. So what is the ABLE all about? Available as a financial planning tool for persons with disabilities and their families. We heard that earlier, right? We talked about a special needs trust. It's also an available tool. Comparatively, so is the ABLE account. Similar to a college 529 savings plan. We had the question that said, is a 529 plan exempt? No. However, you can roll a 529 into a 529A. So a 529A is the technical name for an ABLE account. That rollover is an allowable rollover. The ABLE account provides autonomy and independence to individuals. So with a special needs trust, you're having a trustee and a co-trustee and a trust advisor and an attorney telling you, yeah, you can do that, or no, you can't do that with that money. You can't do that. With the ABLE account, you don't necessarily have that. No one is saying, no, you can't do that. There's a list of qualified disability expenses, which we'll go over, but no one is stopping you from using the ABLE account. There are rules. Social Security does look at it. The IRS does look at it. There are tax consequences, which we can get into if you have questions about that. But ultimately, the decision is up to the owner of the account on how the ABLE account is used. Individuals must be disabled before the age of 26. So that's important to remember. You can be 45 or 72 and open an ABLE account as long as you were disabled before the age of 26. You can have one account per person. So we had the question a while back that said, can you have multiple special needs trusts? Absolutely. I have somebody right now who has a first party trust and 3 third party trusts. They can have as many as you want. One ABLE account per person, up to $15,000 in deposits per year, unless that individual is working, and then their wages can go up a little bit more, $27,000, but $15,000 per year. And there is a Medicaid payback requirement on the ABLE account. It is a little bit different than a special needs trust in that Medicaid is not going to calculate the payback period for as long. So it's just the time that the ABLE account was open. There's also some deductions in there that they calculate first. So it's a little bit different than a special needs trust, but there is a Medicaid payback requirement. And moable.com is a great source to go to learn all of the technicalities about an ABLE account. Qualified disability expenses. So I use the word allowable distributions when I talk about special needs trusts. When I talk about ABLE accounts, I use qualified disability expenses. Qualified disability expenses include assistive technologies and personal supports, education, health and wellness, transportation, and financial management and administrative services. So they're listing their fees as a qualified disability expense. But you noticed I skipped over two. And I want to pause here because there is a major difference in what a special needs trust can do versus what an ABLE account can do. So I will pause for just a second and read the questions. I have, who would you recommend as a trustee when a family is unavailable or can't be trusted? In this case, I would recommend a pooled trust trustee. If you don't have a trusted loved one to serve as trustee or to serve as a co-trustee, I would utilize the available resource of a pooled trust organization like Midwest Special Needs Trust. If we have a special needs trust already, how can I make sure that it's valid? Good question. I would, one, take it to a very trusted attorney, well-versed in special needs trusts and writing special needs trusts. The other thing that I would do is have it approved by Medicaid and or Social Security, depending on the public benefits. They're very technical to write, and there is some very specific language that must be included in a special needs trust, either a first party or a third party. And you want to make sure that that language is there. And any of those resources, so an attorney, Medicaid, or Social Security is going to be able to provide you that information. What is the minimum balance for a pooled trust? So for Midwest Special Needs Trust, our minimum balance is $500. Other pooled trusts have a minimum balance of $1,000 or $5,000, but here at Midwest Special Needs Trust, our minimum balance is $500. And are there limits on entertainment items and events? It seems like a lot could be labeled as that. I will tell you, I pay for whatever entertainment folks want. So as long as there is sufficient funds in the trust and someone is wanting to go and spend a weekend in Branson watching all of the shows, I don't have an issue with it. As long as the trust can sustain the cost of the entertainment items, then I have no problem paying for those things. Can you pay your ABLE account each month to supplement housing expenses? I would do a large distribution from your special needs trust to your ABLE account every year and pay your rent from your ABLE account instead of asking the special needs trust to pay the ABLE account each month to then pay your rent. I do it in one lump sum first and go from there. What happens when the money from the trust is used up while the beneficiary is still living? I close it. So other trustees do other things. Other trustees and other pooled trust organizations have minimum balances. If a trust reaches our minimum balance of $500 or below, I close it due to low balance. And we close it per the terms and conditions of the trust agreement, depending on if it's a first party or a third party. Housing can be paid from the ABLE account. And then Shelley gave us some great examples on when an irrevocable prepaid burial policy should be purchased, right? We can't, special needs trusts cannot make distributions after the death of the life beneficiary. Comparatively, an ABLE account can. So it does have that Medicaid payback provision on it, right? So we said Medicaid payback with an ABLE account. You can pay for funeral expenses before Medicaid's ever going to be paid back. You can't do that with a special needs trust necessarily. So we have Janie. She is 6 months old and is born with a developmental disability. Her grandparents want to save money for her future needs. and plan to give her $10,000 a year. Is an ABLE account appropriate? The answer is yes. The yearly amount her grandparents plan to save each year is $15,000. So an ABLE account would be appropriate. I would argue in that case, grandparents may want to consider a third-party trust because of the ability to not have that Medicaid payback provision and to leave funds to whomever they choose after Miss Janie's death. Thomas is 8. He has a TBI from a personal injury settlement. He receives nearly $12,000 from his personal injury settlement. His family is planning on utilizing the funds for qualified disability expenses. Would an ABLE account be appropriate? Sure. It's less than that amount. It's less than that $15,000. They want to use it for those qualified. That list is perfect for them. And they want to use it for Thomas. I say, why not? In Thomas's case, he could also have a first party trust, right? So he received a personal injury settlement. It's putting him over the asset limit. He could have a first party trust. I think in Thomas's case, either one works, depending on what the family wants to use those funds for. So we have a little bit of a comparative analysis with special needs trusts and ABLE accounts. The ABLE account may be better in some ways when it's desirable for the beneficiary to have more autonomy and independence, and the beneficiary has the ability to responsibly manage the account. So again, no one is telling them no when smaller amounts of money are involved. So Thomas got that $12,000. An ABLE account, it may be a really great idea for him. Third-party donors aren't concerned with the Medicaid payback provision. And we have some that aren't concerned, but we always want to make it very clear that the difference between a third-party special needs trust and an ABLE account is that Medicaid payback provision. Individuals with lifelong disability who wish to conserve assets after the age of 65, and I did not get into that. If you have questions about somebody over the age of 65, please let me know. It's very technical within the Medicaid policy. Special needs trust may be a better option. And I'm going to shout from the rooftops that a special needs trust is always the better option, but I am never going to say an ABLE account is not an option. So when the annual contribution rules are too restrictive, somebody has more than $15,000 that they need to put into a special needs trust, or they need to conserve those funds to remain eligible for public benefits. An ABLE account that's too much money for them, right? When an ABLE account, disability related expenses are too restrictive. And I would say that this is kind of an old school thinking from years ago before folks had really worked out what qualified disability expenses are. Almost anything these days qualifies as a qualified disability expense, down to clothing and shoes and specialized utensils, and all of those things would be qualified disability expenses. When multiple accounts are necessary or preferred. So we talked about ABLE account, one account per person, right? Special needs trust, as many accounts as is necessary. So my example of the individual with a first party special needs trust, she received a personal injury settlement, first party special needs trust. She then had 2 parents, mom and dad divorced, each set up their own third party special needs trusts with different remainder beneficiaries. And then subsequently, grandparents came back around and said, we want our own remainder beneficiaries listed. We're going to set up another third-party trust. They didn't all want to share the same account, right? They all wanted different remainder beneficiaries listed. So an ABLE account was not appropriate for them. It is also a better option when a disability happens after the age of 26. That may not be the case for our folks here in a lot of places, but may be the case for those that receive personal injury settlements. They may get in that tragic car accident at the age of 54. They wouldn't be able to open an ABLE account. To protect third-party assets from Medicaid payback, and when a professional trustee with special knowledge of disability services and public benefits is essential to protect the interest of the beneficiary. We've talked a lot about public benefits and the differences between SSI and Medicaid and special needs trust and ABLE accounts. you're really going to want to have somebody that understands what all of that means and how they all work together. And sometimes with an ABLE account, you don't have that person. And the ABLE account is not a great resource to ask questions on if something is allowable or not allowable. With a trustee or a pooled trust organization, you're going to have somebody available to you to answer those questions and make some of those decisions for you. Both may be a good idea when all criteria of the ABLE account are met. So if you meet the criteria for an ABLE account, you likely meet the criteria for a special needs trust, not vice versa, right? Because we talked about that age limit. The proceeds can be divided between the two financial tools for maximum benefit. So if you have $25,000 needs to be protected into, but benefits need to be protected, you can put 15 into an ABLE account and 10 into a special needs trust, or however that math works best for the beneficiary. You can pay for supplemental needs from the special needs trust, so cable and medical bills and transportation, and qualifying disability expenses from the ABLE account, including housing. And you can make that transfer from a special needs trust to an ABLE account. Right now, Shelley and I are seeing lots of distributions for that yearly distribution from the special needs trust to the ABLE account. So it is a regular occurrence. So again, thank you for spending this evening with us.
All right, so just a real quick introduction to everyone. My name is Michael Chiodini. I am a personal financial planner. I have been in the industry for about 20 years. And about 15 years ago, I was put in a position as a parent of a child with a disability to kind of figure out what I needed to do, kind of to plan for his future. And so I kind of engulfed my whole career and my life into kind of learning and understanding and helping other families kind of navigate both the government infrastructure of benefit eligibility, helping them understand estate planning, as well as kind of the financial components of how do I make sure that my loved one is best cared for with the quality of life that we're looking for. And so just as this slide says, I do believe it does kind of, it does require kind of the assembly of a team of people, looking at special needs planning attorneys, financial advisors, other professional caregivers, trust officers, and other folks in people's lives that are going to have an influence and maybe some input into how we can best, kind of provide that future for them. For when, unfortunately, we're kind of planning for when we're not here. And so while we are here, we're trying to put those plans in place. I think it's important that families kind of understand the costs associated with their child's disability. I often use my own son as an example where Dylan's needs were very high. And so the living arrangements that we had planned for could drastically differ in cost depending on what that lifestyle looked like for us and for what our dreams and hopes were. So I think it's really important that families understand what the public benefit of eligibility and ability of services are. So I would say that the services are super plentiful, but there certainly are a great deal of resources out there, and there's great supplemental opportunity for us to help families kind of build that plan that incorporates, their own personal financial ability, as well as the state and local services that they can access through the financial planning, the special needs trust planning that we find is so important. And then the last part is just developing a plan for the funding of the lifetime care. So I think of it as like retirement for the next generation, right? My goal was to make sure that my family, my wife and I kind of met our goals to retire, but I also felt it was really important to make sure that there was enough money left over and that we had planned accordingly for Dylan in case something were to happen and we weren't here to be there for him. We needed to make sure that there was as much as we could there to help support the lifestyle that we wanted for him. So I kind of start with this following kind of list here what parents should do. I'm going to hit on really the first two. I think we've touched on the majority of the rest of the items today. But just to kind of start at the top, I think it's critical parents start with creating a letter of intent. And a letter of intent, and the way I look at it, I think it's about every part of that individual's daily life, their routines, their programs, their therapies, events, things they like, things they enjoy, medical procedures and treatments that they need to have, or that maybe in the future you would be willing to accept or entertain for your child. I think friends and family involvement, and I think of like the people in my son's life that were very instrumental in both his daily life, but also just some of the things with vacation and or Cardinals games. Dylan really loved going on horseback riding with a therapeutic horsemanship. So all of those things I think are really important, because as parents, we know our loved one more than anyone. We know, or as a caregiver, we know what they need and what their hopes and dreams are mostly. And so our goal here is to kind of create a kind of a letter of intent or a booklet, or in my case, it was a videotape of, the things in his life that people that were going to step in our role would need to know in order to do the best job possible for him. So that's kind of the goal of the letter of intent, is try to get that plan out in place. And I think it really helps drive the whole plan, because I'll give you an example. If you have an individual and the goal is to keep their home, and I will use my son, Dylan. Dylan did not walk, talk, sit up, roll over, wheelchair bound, G-tube fed, full care, 24 hours a day. So in our own home, it's very likely that there was a gap in coverage of what Medicaid, for example, may or may not cover as far as personal care, nursing attendants and whatnot. And so in a setting like our own home, if for to say we were able to only get, let's say, 18 hours a day of help, that left 6 hours a day that needed to be filled. And if we had to pay somebody at, $20 an hour, it's $120 a night. That's, $3,600 a month just for the small amount of hours that weren't being covered through Medicaid in that scenario. The other option would be maybe like Coney Bird, if you're familiar, or like a nursing home for children and adults that are non-ambulatory, like my son. And that's covered by Medicaid, right? So it's a group home. It's, multiple roommates. It's great. It's just not what we want. It's not what our plan is and what our hopes and dreams were. But I think the letter of intent for each family is extremely different. And it really helps us to kind of understand, from a legal aspect and from a financial aspect, what does this plan need to look like? Because really each individual situation is different. And I think it gives us a lot of ability to help guide that family on, what are the pieces that they need to be looking at. Oftentimes we're left with, what can be funding of a special needs trust? So what are the assets that can go in it? And really the answer is anything. But the reality is a lot of times families are looking at their money and they're getting it two purposes, or dual dollars, if you would. So the first purpose is, for mom and dad's own retirement, right? And then we also want to leave this money to Joey in the case that, Bhavik was using. Well, the problem there is what happens if something happens to mom or dad, and either A, they spend through those dollars, or B, something in their own life happens to where now they need care, and we haven't planned or thought through what will we do in that situation, and how would we act financially in that situation, and how would that impact the benefits and the monies that we're trying to leave to the next generation. So in the years that I've been doing this, and the few things that I could tell you right off the bat, a lot of times life insurance is a tool that's used in special needs planning because it creates money where there isn't any. It immediately creates the money when the need exists. And so a lot of times, especially with our younger families, we see lots of life insurance for not only mom and dad and income replacement, but also as a tool to fill the special needs bucket when mom and dad possibly are no longer here. So a couple different thoughts around that. There are very unique types of life insurance that exists out there. One that comes to mind is one that I see used a lot, where it insures both parents, or two lives, right? Two caregivers, an example, and it only pays its death benefit at the death of the second caregiver. So it works in a way where it's not for mom and dad. It's not income replacement. It's strictly a legacy goal. It's a tool to leave assets to the next generation at the most opportune time. It's tax-free, which also is nice, right? But what I like about it is it allows us to look at a couple different things. And I'm trying to find the slide here real quick. But one of the things I really like is the idea where you're essentially having life insurance with long-term care insurance connected to it, to where a client can take care of the need to leave assets at their death, and also possibly protect the rest of their assets in the need of a long-term care situation. And so I'm not on the right slide here, so I do apologize. When I find it, I'll bring it up. But essentially what you have is multiple ways of funding both the special needs trusts and the concern that I think as advisors we have, which is what happens if something happens to mom or dad, and now we're spending their money on their care, and therefore dwindling what may there be left over in the case of the special needs trust. So this is just a little bit of a slide that kind of shows you, there's multiple products, there's multiple tools. Every family is different. In my family, with my father, we had a situation where he could not get long-term care insurance. And so our family plan was my wife to take FMLA and to stay at home and care for my father if that time ever came. Luckily, it did not come. But it is something that, we look at from a planning perspective. And if there were one thing to say, it would be, of all the families I work with, the families that have loved ones special needs, if they're trying to make certain that there's money's left over for them, these are very important. Your estate plan is important, your financial plan is important, but also I think the protection of your assets and your potential need for care for yourself, and making certain that all the holes in your financial boat are attended to, because any one of those things could really sink the boat. And we're not, I look at myself, and if my parents die and I don't get any money, I'll be fine, right? But I look at my son Dylan, and I look at the children of the families that we serve, and that's just not an option. So we have to make sure, no matter what, for certain, with 100% likelihood, that the monies that we're trying to make fund that trust get there. And we get there in a time period that, that's consistent with that family and with their goals. And I also do think, as I stop this, I do think that every family is different too, because every plan somewhat can be related to the situation and the family that they're working with. And so I'll use my Dylan, for example. So, I felt like Dylan would not have a long life expectancy. He had a lot of medical problems, a lot of issues. And so my planning was very flexible. It was very movable and interchangeable. And I knew that it needed to be that way in the event that something like where Dylan passed away before us, so that I didn't, in a sense, put all these dollars and efforts into this plan for when I'm not here, in the event that actually that he goes first. And so I think it's really important for each family that they, kind of walk through their life and their letter of intent and their child's situation, their loved one's situation, and try to really dial up a plan that really is personal to your situation. And I find that, that's just kind of the best way to go about it, because there really is no cutter plan. Every situation is extremely different.
Yeah, we have a question. It says, when should a special needs trust be set up, and at what age? It's a real difficult question to answer, I guess. I think that cliched answer would be set it up now, because we don't know what our crystal ball says about our future moving forward. And it's one of those things that you can't set up when it's too late. Or you're in a Medicaid payback trust land, or that reactive bubble that I was talking about. There is no age requirement. You can set up a special needs trust for when Joey's 1 year of age, or frankly, 75 years of age. And so it's just a matter of having your ducks in a row and being proactive, which is always, it's always a tricky thing because, you know, you don't want to do everything on day one, but at the same time, you don't want to do it on year 100 either. So,
hey, Bhavik, I always used to tell people it's always easier to undo a special needs trust, right, than it is to be finding yourself in a reactive situation like you mentioned tonight.
And I will tell you that the number of panicked phone calls I receive on folks on that reactive end who have an unplanned inheritance and have the 15 days left in the month to put it in an exempt asset, it speeds the process up, right? So we don't want to be in that situation. We love it when folks plan ahead and can help with that at any time. And I recommend any age for a special needs trust. Absolutely.
Someone asked about what the cost would be for setting up a special needs trust, and there's multiple answers. So let me kind of go through that. Casie, you might want to correct me if I'm wrong, but essentially you could do the attorney drafted one. And then those are going to probably range, I don't know, from $1,500 to $5,000. I mean, I'm sorry to give you such a wide range, but there's so many things and moving pieces of what kind of type of planning, but that would be the general range. And then there's the pooled special needs trust that was talked about and learned about today about the Midwest Special Needs Trust. That really doesn't have, I mean, $250, $500. You tell me, Casie. What
$750 is our maximum enrollment fee. And we do have the option. I didn't mention this in my PowerPoint. You talked about a testamentary trust. We have the option of an inactive trust, which is also a low cost available for kind of estate planning and working on some of those assets that you want to feed into a special needs trust. So that's a low cost option as well with us.
Able account. Age for an able account. Again, there's really, I don't believe there's an age limit as long as you can establish that you were disabled prior to the age of 26.
Correct. I would agree.
That's the only requirement there. Able account money, can it go to another family member after Joey dies? Yes, there's the ability for there to be beneficiaries named on it, but keep in mind, at least from my way of looking at it, able accounts are still reactive category. And whenever anything's in the reactive category, there's a reimbursement back to the state element to it that has to be satisfied before it could go to wherever the beneficiary named in the document or named in the able account could go. So that would be my response. Any added responses?
I would add to it that the able account is always going to default to probate. So if you don't list anybody, unlike a special needs trust, we're not defaulting to probate, at least at Midwest Special Needs Trust, but an able account is going to default to probate. So somebody that you may not want to receive those funds left over in an able account after Medicaid payback, after funeral expenses, may receive those funds after your death. So either list it beforehand or put it through a special needs trust.
And then there's what if your trust is set up to not receive money until parents die, i.e. what I was calling a testamentary special needs trust, but other family unexpectedly leave money to my child in the meantime. Well, if they've left it already, if this has already occurred, then you are really in the reactive zone. You're in the reactive category. And your options are going to be to either convert it to an exempt asset, like put some money in the able account, maybe pay for a prepaid funeral, or depending on how much it is, if it's a lot, maybe even putting it into a first party or a self-settled special needs trust. And again, that could either be a pooled version or a customized drafted version, either one. But that are all the vehicles of reacting to if already the money is directed to go to the child and the family member already died, and that's happening. If the family member hasn't died yet, then you could become proactive. You could convert your testamentary special needs trust or update it to make it standalone, so it's in existence now, and then give the name of that trust to your family member so that they can direct the assets into that, or use the third-party pooled special needs trust that you learned about with the Midwest Special Needs Trust?
I would say that if you are looking at kind of pooling third-party funds, so if you have a donor over here and aunt over here, you want to make sure that you agree on what those remainder beneficiaries are. So if as long as everybody's in agreement, we all want to put everybody's money in the same pot per se, then absolutely. Otherwise, auntie needs to set up her own, mom and dad, whomever, need to set up their own third-party trust. But yeah, if it's already been done and that money's left to the beneficiary, you have just a couple of options and need to move real fast on that.
Yeah, Mike, that was your real life story, right? With what your father-in-law wanted versus what you wanted.
Yeah. So what I had done is my father-in-law had come to me and said, I want to put, a little bit of money away for all the kids for college. What do I do for Dylan? And I said, well, I'll get a special needs trust together and I'll have an answer for you. So I went and paid the money and had it drafted. And it was my wife and I's trust, special needs trust that we created for Dylan. And it said that when Dylan dies, that the money comes back to my wife and I. And so my father-in-law, when I brought it to him, he's like, well, what happens when Dylan dies? And I go, well, the money goes back to Debbie and I. And he's like, no, that's my money. I want that going to my girls. So he actually went out and drafted his own trust with his own provisions and his own dispository strategy as to whom he wanted it to go to. So yeah, it was quite funny. Expensive mistake, but I ended up using the trust anyway. So
yeah. There's another question that says, to be clear, maybe Mike, you could take this one too. Do all assets inherited have to be labeled payable to a specific special needs trust?
So if I understand the question right, which I believe is, if I'm intending to leave money to Joey, do the titling and the beneficiaries on those assets have to specify the special needs trust? And I would absolutely say yes. I've actually seen people write down the name of a trust that didn't even exist, which you cannot do, right? So you have to create the trust. It has to have, some existence and some language to go with it. But I think the right answer here, Bhavik, I think you're nodding with me, is absolutely, it does need to be specified to the trust. Otherwise, I think that person finds themselves in a reactionary situation when dealing with Medicaid payback trusts and ABLE accounts.
Yeah, no, spot. I agree. Okay, so another question that was, if we as parents set up a third-party special needs trust, when and why would we need to hire a third-party trustee or trust manager? Do we necessarily need that? You may get a couple of answers here, so we'll go around. I guess I'll kick it off and say, not every special needs trust has a professional or corporate trustee. In fact, most of them probably don't. And a lot of people, you'll set it up originally where mom and dad, parents, would be the trustee probably. And then down the road, you might have a sibling or an uncle and aunt to Joey, whichever way relationship you want to talk about. That could be the trustee, could be trusted friends, family, so on and so forth, that you can name. And then it does change the cost administration, right? Because those folks probably aren't going to charge for the role, so on and so forth. Now, other families don't want to obligate the family members, don't want to put that burden on them or that work on them. And so they may decide, I want to go professional, whether it be a bank, a corporate trustee, or something like Midwest Special Needs Trust. But those do have annual fees. Those are going to have cost to it, but it does sometimes avoid conflict or family dynamic, like peace keeping for the family, things like that. So I that's sort of my reaction to that question, but I think everybody might have something to add to that.
All I was going to say is, no one was ever going to replace close family that care and that really look for them, right? But the reality is not everybody has that, and not everybody has the people that they trust. And so, you really got to look deep into the word trustee, meaning the root of the word trust, that these are people that are going to do good work. And sometimes they're just busy professionals. I mean, if you asked me to take on the role of a very high need, client with trust disbursements, to be that, I ain't got the time for that. So I would hire the trust officer just to, come to me with executive decisions so that I don't have to deal with that stuff in my life. So everybody, I think, situation to Bhavik's point is different. But I always just look at it and say, you're never going to replace people that, that care and love about them, that are family, that are around them. But you also got to protect sometimes them. I talk about pillow talk. Sometimes you don't know who they're going to marry and what that influence has on them or whatever. So that trust company does have that other aspect. And then I'll leave it with this. I tell every family, at the end of the line of people, if you run out of people, you need to come up with a trust company at the end, because that's a problem. So if nothing else, at the end of your document, you'll probably have a trust company named, or we'll recommend that.
My added piece to that is whomever you choose. So trusted family member, friend, trust officer, trust organization, make sure that they are well-versed in special needs trust administration or understand how to learn it. Because we've said, like I said, we've talked about Medicaid, we've talked about SSI, we've talked about allowable distributions and qualified disability expenses and what Medicaid covers and all of that. And to just put that on somebody and say, now it's your turn. You'll figure it out. They may not. And then you have benefits that are adversely affected, which was not the intent at all. So with a minimum, a pooled trust organization, you're going to find people who are knowledgeable in public benefits. At a trust organization or a larger corporate trustee, likely they have somebody who's trained in special needs trust. And then as you go higher, the specialty becomes much more focused that way. But you absolutely want to know that they are comfortable within public benefits alone to do that.
But just to add to that, in terms of special needs trusts, and I mean, just very candidly, I probably draft more of them than anybody in the state of Missouri. And it is not easy to find corporate trustees that want to even take that on anymore because they're complicated. And so then what they do, because everybody's trying to make money, is they say, well, yeah, we'll do them, but you're going to have a minimum of like $3 million in the trust. So, you're absolutely right in the sense that the pooled trust and Midwest Special Needs Trust, they definitely are. Well, one, I don't care. Corporate, if you have 5 million, 10 million, 20 million, specialists for special needs trust administration. Midwest Special Needs Trust is going to be, Shelley, this is a compliment to you. It's going to be hard to beat you in the expertise because it's so highly specialized and it's so focused, and you've done so many years of expertise in that area. Now with that said, because a lot of people, again, are still going to name family members. It's just kind of the way the world works. And someone asked, like, what do you do to train them? It's the next question for your role as trustee. Does the attorney prepare you? I always think the kind of trait that a trustee should have is the kind that's going to take prudence and be curious and seek counsel when they don't know the answer. In other words, not someone that's going to knee-jerk react. Like if they know it, great, boom, go do it. But if they don't, they're going to need to know to ask, whether it be asking sources like Midwest Special Needs Trust, whether it be asking for special needs planning attorneys or folks that are in the advisory world like Mike. They're going to need to ask what they don't know. In other words, it's got to be people that you educate to say guesswork is not good enough. You must know what you're doing. And if you don't know, you must find out. There are certain training programs out there from time to time that you could find, but they're going to be very large stroke, very broad stroke, very macro level. They're not really going to train you to any significant level. So that's the best way I can answer that question is you've really got to go seek out the answer if you're uncertain. Now, if you do it for 5 years, guess what? You're going to learn a lot more and you're going to know how to do things. And that's obvious. If you move out of state, does that affect an able or special needs trust? I mean, that's a really broad question. Could it affect it? I mean, potentially, but I don't really think adversely. I mean, like you can have a Missouri able account and live in another state. So there's that. And then your trust that you create is valid even if you move to another state. Could you move to a random state where it might be beneficial to put little tweaks to the trust or something like that? Possibly. But generally speaking, I think you're good to go as long as you've established and it was valid where you established it. Any recommendations to trust companies? Can you start with a family member and then go to the Midwest Special Needs Trust at the end? I will leave the second question to Midwest Special Needs Trust. The first one I would say is, if you are going to go trust company, just understand it's not all or nothing. Sometimes you can do a co-trustee relationship, like to the point that Mike brought up earlier, which is you're going to love the people that loved ones in your life are going to you're going to feel comfortable trusting, thinking that they're going to go the extra mile, so to speak. Though oftentimes that might not be the case, but you get what I'm saying. You could have them be with a corporate trustee so that you have sort of this best balance of all things, a technician that knows what they're doing, a liaison to the family. Recommended trust companies. That's a really broad question. I'm going to give you a really weak answer unless someone wants to qualify it. They have to have a trust administrator that actually specializes in special needs trusts. And that is probably far and few between these days. And then I'll let you answer the Midwest Special Needs Trust part of it.
So in all of your estate planning for your loved one with a disability, I always recommend listing a pool trust organization or Midwest Special Needs Trust specifically as a successor trustee because they're balanced. So we talked about how some trust companies, they're only going to take it at $3 or $5 million. That means their minimum balance is 1.5 million or 500,000. That's still too much, right, for public benefits. So somebody is going to have to come in, or there's going to have to be something within the trust document that allows a successor trustee to take over at a certain amount. And so I've seen trust documents come across my desk that said MS&T, like enough for somebody to know to call me over here in Columbia, call Casie. I mean, I've seen it all. And as long as the intent is there that Midwest Special Needs Trust or another pool trust organization is to serve as successor trustee, but I always recommend that in whatever you're planning you're going to do, whether you start off with us or you don't, that at some point you have a successor trustee listed because you don't know what that minimum balance is.
What if I have a sibling listed as a successor trustee, but their life changed too much in 10 years or where they don't and can't do it anymore? What are my options? Well, assume it's again, without looking at the trust, I might not be perfectly answering your question, but most trusts, at least properly drafted trusts, should have a game plan in place that would allow for the trustee to be changed or modified depending on capacity or even disagreement of some sort, estrangement, whatever. And as long as it has that flexibility, that's a great way to handle it. Now, if your existing trust does not have that kind of flexibility, there may be ways to still modify the trust, but that becomes very trust by trust specific. Might be one of those things to have someone look at your trust to be able to answer that specifically for you. But it should normally be drafted with enough flexibility to accommodate being able to switch it.
Great job, all of our panelists. Thank you all for being here this evening. And thank you all who participated tonight. And we look forward to seeing you in the future.
Thanks, Ann.
Bye,
Thanks, everyone.
Bye, everyone.
Bye-bye.